SJC-12448, Deborah Armata v. Target Corporation.
Mr. Lemberg, good morning.
Good morning, Judge.
It's still morning. Morning in America.
Good morning. My name is Sergey Lemberg. I represent Deborah Armata. I represented her below. The goal of the provision at issue in this case, and I quote, was not only to limit the number of times a creditor can communicate with the debtor via the telephone to try to collect the debt, but also to limit the fees a creditor can impose on a debtor. And I want to tell the court today that there's a significant impact that this decision will have. Massachusetts population is about 6.9 million people. According to published statistics, 1/3 of the American population has a delinquency. So the decision you will make in this case will impact more or less 2.5 million people. Now, what my brother will argue today is that this regulation, which was aimed at limiting the number of times creditors can call debtors, in fact allows Target to call Ms. Armata and millions of other people, or creditors rather, 4 times a day. That is 1,424 times a year. Now,
I'll actually stop you for a moment. Target imposed its own limit of 4 times a day. Is there anything that would have barred them, apart from what you say is the regulation, from doing it 10, 20 times a day?
the kindness of their heart. But in my experience in these cases, 4 times a day is a relatively timid limit. And there are creditors out there who will call more than that. Not in Massachusetts, in other places. But they will call 5, 10, 20.
And why not in Massachusetts? Is there any regulation or restriction which bars them from doing so in Massachusetts?
940 CMR 701F.
Wait, that bars them from leaving a message?
Sorry, is that the one you're citing for this one, or is there a different?
This is the regulation at issue in this case.
Basically, it all rests on this regulation.
Yes.
So so you're saying that if we do not agree with you, we open the door to them calling 10, 20, 30 times a day?
Each creditor.
As long as they leave no message?
As long as they leave no message.
Leave no message, is that what you're saying?
As well, if you interpret the regulation consistently with Justice Ferraro's decision below, and not the way that it was interpreted in Watkins and Royce Medeiros, then the answer is they can call as many times as they want, as many days as they want, for as long as they want, and nothing in this regulation or any other law, because the Fair Debt Collection Practices Act does not apply to creditors.
Can you block the number so that they couldn't get you at all?
I could. Most folks would find it more challenging.
So if you knew how to block the thing, you could stop it altogether?
Actually, you can't. Because if you look in the record, you'll see that there's about 20 or 30 phone numbers from which they called. So you can try to block, but you'd be unsuccessful because the numbers rotate, and most creditors buy additional blocks of numbers for that very reason, because a lot of people do block.
So the only way they can stop the number of the calls is the only way your client or anyone like her could stop the calls is by picking up the phone. Because if she picked up the phone, they could only call twice, right?
If she picked up the phone twice,
then they're done.
They would still call.
No, but then
They could still call, so long as she doesn't pick up the phone that additional 3rd time, the regulation wouldn't be violated.
Right, but if she picked it up twice and then they called you a 3rd time, then they're done. They're in violation, right?
Under their interpretation, they're only done if she picks up 3 times.
Right, but I mean that what you want is, they're saying they can't, you're saying you can call 100 times. You can call 100 times if you don't pick up. But if you pick up, you can only call twice, because then the 3rd time you're in violation, right?
Almost. So,
What was that? I didn't
I
hear
said
the-
almost.
Almost,
The way they read this reg is a communication is only initiated when a conversation happens. Short of a conversation, there is no initiation of a communication, there is no violation of the regulation and 93A. Now,
Wait, so leaving a message doesn't count as as a communication?
leaving a message does count.
Okay. Can I ask you a question about the regulation here? Do you think it's ambiguous?
I think it's a subordinate clause that's at issue. I think Justice Dupuis, who had been in the Attorney General's office before she was on the bench, she picked up that grammatical issue. It's a subordinate clause. I think that it's set off by commas, and that typically means for subordinate clauses that it is non-restrictive, meaning, as she said, she alluded to this issue, that it provides additional information, but it does not limit the noun that it precedes.
Now, are we talking, which one are we talking about? Which clause are we talking about here?
The regulation reads initiating communication with any debtor
Right.
via telephone, comma, either in person or via text messaging or recorded audio message. So the clause beginning with either is set off by commas, and typically that suggests it's a non-restrictive clause.
That's actually not the ambiguity I was looking at. Let me ask you about this one. It says initiating a communication, right? So starting a communication, isn't that different from completing a communication?
Crystal clear. The statute is not at all ambiguous on this issue.
Okay, so you've got initiating a communication at the beginning of the regulation, but then it talks about doing this in excess of 2 such communications. Are we talking about, what are we talking about here? 2 such communications. Are we talking about the initiation of a communication, or are we talking about an actual communication?
I think we're talking about the initiation of communication, and this is why I say that. The parallel statute, the Fair Debt Collection Practices Act, does not have the word initiate in it. Now, that regulates third-party debt collectors. There's nothing on the federal level that regulates creditors. This regulation regulates creditors. And they had, because the language is so similar, they had to have seen the Fair Debt Collection Practices Act and made a conscious decision to insert the word initiate, which comes from Latin to begin, a communication, meaning they wanted to prohibit, suggesting that they wanted to prohibit even the beginning of the start of a communication, not just completed communications.
And do you get, I think the Attorney General has some guidance on that?
Absolutely.
And can you tell us about that a little bit, the unsuccessful attempts and whether they leave a message or
Unsuccessful
not?
attempts by a creditor to reach a debtor via the telephone may not constitute initiation of communication if the creditor is truly unable to reach the debtor or leave a message for the debtor. Now, I asked myself as I was sitting here, geez, why didn't Target argue that? Well, there's an easy answer for that, because they have a policy, and their policy was to call 4 times a day. And so they couldn't reasonably argue that they were truly unable to reach Ms. Armata, because under their policy, they were set to call 4 times a day.
Well, they could have left a message too, couldn't they?
Well, in fact, the record is that they did leave several messages for her. I think it's 208 to 204 somewhere. They did leave, although they argue in the brief that it was a physical impossibility, the record, in fact, the interrogatory answers, I think it's interrogatory 10, says that they did leave several messages for her. Now, they say, well, that was a different machine we used, or whatever the qualification in that. But it's not a physical impossibility.
Does the record show she has an answering machine? Because if she has an answering machine, you assume you can leave a message, but the phone hangs up before it leaves. So So do we know if she has an answering machine?
I won't commit to a 100% answer on that, but I believe that what the record shows was that the dialer, the automatic telephone dialing system, which they use, and they call it the predictive dialer made by Avaya, senses when the voicemail picks up and does not leave a message.
So if you don't answer if you owe money and you don't answer the phone, the creditor can't collect the money, and after they've called enough times, you can sue them for money when you didn't pay them back.
I knew I'd be asked that question, so I prepared an answer. The answer is that Massachusetts is unique, and Massachusetts protects the citizens of the Commonwealth from incessant telephone harassment. There's few states, maybe not unique, but almost unique in the Union in that regard. And in Massachusetts, they can call twice a day. They can send you as many letters as they wish to send you. They can go to court and collect the money.
That'd be a good job. You go out, you get credit cards, you don't pay them off, and then you wait for them to call you a number of times, and then in addition to the free stuff you got with the credit cards, you sue them for additional money.
I think the statistics show that most people who fall behind on debt are not, in fact, looking to take advantage of the system.
No, that's not my point. My point isn't that that's going to happen. My point is that your interpretation would result in that being able to happen, and that means we have to look at whether it's a reasonable interpretation.
A debtor could incur debt. A debtor could then fail to pay the debt. A debtor could then manufacture harassment case.
You don't have to
and sue
manufacture it, just don't
or
answer the phone.
I think those are the possibilities. I think in this case, this didn't happen. And in the vast majority of other cases where I represent debtors, what happens is that people fall on hard times. The largest single cause of bankruptcy in the United States is medical bills. And by the way, this regulation would apply to medical bill collectors just the same.
Go ahead.
I think it's a possibility, Justice, but I think it's a remote possibility. I think the reg was promulgated to protect people's peace of mind.
I think it's a remote possibility, too. I'm just trying to understand if you're asking for an interpretation that sort of doesn't make sense, so that wasn't the intent. That's the reason for my question.
I think the intent was to do exactly what we were asking the court to do. And the reading that my brother will advocate is contrary to the intent of the regulation.
You've done a number of these cases, and you've given us, has the AG weighed in any of these cases? I mean, we had them here this morning. It would have been nice if we had an AG interpretation of this case. Has the AG weighed in on this basically calling and hanging up issue besides that little regulation?
The associate who helped me prepare for this hearing today asked me.
Sorry.
The associate who helped me prepare for this hearing today asked me this very question, and the answer I gave him and the answer I will
think
give
you
you.
should give him a raise, but separate and apart from
The
that.
answer is no, Justice.
Okay, so they have not weighed in officially in this area. All we've got is that guidance in that the stuff about unable to pick up or whatever it is.
The guidance to which substantial deference is owed.
Your brother, I'm sure in a moment, will tell us, as I think he said in his brief, we can't leave a message, because if we leave a message, we don't know who's going to pick up that message, and that arguably would put us in violation of another rule, which says that you can only communicate to the debtor herself.
In my preparation notes, there's a small section for red herring arguments, and I think that this was one of them.
We are so predictable. Okay, go ahead, address that question.
The issue there is this. First of all, Target is not a debt collector. So whatever case law there exists that limits or restrains debt collectors from leaving messages does not apply to Target. Second of all, to suggest that creditors and debt collectors in the United States don't leave messages because it's impossible and they'll get sued is simply contrary to the truth. In fact, millions of messages are left every single day. And they have a little bit of a challenge, these folks, because there are different decisions coming down from different courts around the country, different circuit courts, on whether some information constitutes communication and some doesn't. But they can leave a message. They can say, this is Target, please give us a call. In most places, there wouldn't be anything wrong with that message. They don't even have to say, this is Target. Well, let me retract that.
They don't say that.
I'm not
then
sure. I'm
how are
not
we
sure
supposed to
that
hear?
there's another section of the regulation that may apply to that. But long story short on that answer is, of course they can leave a message. And in fact, the record here shows that several messages were left for Ms. Armata.
And did the record say what they said?
No.
Okay, thank you.
Thank you very much.
Mr. Melendez?
Thank you, Your Honor. May it please the Court. Brian Melendez for Target. Mr. Lemberg has made a policy argument about what he believes the law ought to be and what he thinks the intent of the Attorney General was in adopting this regulation. I would like to make this argument from the point of view of Target, which only knows what the regulation says and what it requires us to do and what it prohibits us from doing. And I'd like to start, Your Honors, where the Superior Court ended, which was by concluding that there was no communication initiated within the regulations meeting. By the way, Mr. Lemberg said several times that there is evidence that Target left a message. That's not exactly true. There are 4 calls in the call records that are not debt collection calls. They were coming from, we believe, from Target's pharmacy, and it's disputed about whether Ms. Armata ever had a pharmacy account, but Target's debt collection never left a message for Ms. Armata, never left a message for her, never left a voicemail. Your Honors, the regulation defines communication as conveying information directly or indirectly to any person through any medium, with an exclusion that is not relevant here. Target called Ms. Armata a number of times, and by the way, it is not our policy to call 4 times a day. In fact, I think we never called her 4 times a day. There are 2 7-day periods when we called her more than twice during the 7-day period, but I think we were generally calling her only once or twice on the days when we called. Our policy is never to call more than 4 times a day under any circumstances, but we almost never do that. And by the way, before I get back to the text, one of your honors made a comment about, well, Mr. Lemberg made an argument about, well, you know, Target could call 10 or 20 or 100 times a day. The only thing that Ms. Armata would have needed to do to stop the calls is to pick up the phone and say, look, I don't want you to call me anymore. We called her at the number we were calling her because she gave us consent to call her at that number. Under the federal statute, the Telephone Consumer Protection Act, all she has to do is revoke that consent in any reasonable means, and we are no longer allowed to call her. She would have only had to pick up the phone and tell us once, stop calling, all calls must stop, otherwise there's massive liability. I'm sorry?
What statutory or regulatory provision says that all she has to do is say, don't call again? That's a very valuable piece of information.
The statute, Your Honor, is the Telephone Consumer Protection Act. It is Title 47, United States Code, Section 227.
Title 47 what?
United States Code, Title 47, so 47 U.S.C. 227.
And that provision says, if you're a debtor and you don't want to hear from your creditor, you just tell them, don't call me again, and that shuts it all down. Wow,
It doesn't speak in terms of debtors and creditors, Your Honor. It is anybody using an automatic dialer to call a cellular telephone or any number of other kinds of devices. So it doesn't matter what kind of call it is. It's actually aimed at telemarketers, but it covers non-telemarketers as well.
So that's basically an end-all call provision. federal end-all call? I hope there's no subtlety to this that I'm gonna go back and read afterwards and discover, and then say, oh, man.
It doesn't apply to every call in the universe, Your Honor. For example, it doesn't apply to calls to landlines, but it applies to every call to cellular telephones, so it applied to every call at issue in this case.
So it only applies to cell phones, it doesn't apply to landline.
It applies to cell phones and certain other kinds of calls. Your Honor, if you're familiar with the National Do Not Call Registry, it's the same statute that sets up that registry. Now, that's not at issue here, but it is certain that the calls to Ms. Armata fell under that statute. And all she would have had to do under that statute is to ask us to stop calling. We would have been obliged by federal law to stop.
But I had thought that, I've not looked at the federal law, but I've read what you said about it. I thought the federal law said you can't use automated telephone systems to call cell phones.
Unless you have prior express consent from the party, which we had from Ms. Armata. So when she gave us her phone number and said, this is the number.
And where did you get that from?
Under an applicable ruling from the Federal Communications Commission, which enforces the TCPA, when a customer provides a phone number to a creditor or anybody that they're doing business with, that is the provision of prior express consent. And I don't think Mr. Lemberg would dispute that. We had prior express consent to call her. All she would have had to do is revoke that, and to revoke it, all she would have to do is pick up the phone and say, please stop calling me.
But is this really the point here? Isn't the point, what is the meaning of communication within that,
Thank you, Your Honor.
that regulation?
Yes, I meant to digress for just a moment, and then I got led further down the rabbit hole, so thank you for bringing me back to my argument. There was no, communication is the conveying of information. There is no dispute that Ms. Armata never spoke with a live human being from Target. We never sent her a text message. We never left her a voicemail.
Target was calling.
Apparently she did. I don't know how she knew that, but she seems to have known that.
Oh, I suspect she knows it because Target pops up in
But that's probably right, Your Honor. I suspect that too, but that's not in the record.
data communication. Target's calling me. I owe Target money.
And they're really persistent.
Well, if we can't talk to her, there's no information
I'm
conveyed.
not saying you're doing anything wrong, but I'm just
Sure.
asking, is that when that phone beeps up and says Target, that's a communication, isn't it?
I don't think it is, but Your Honor, even if the court believes that it is, that's not enough to establish liability here, because in order for there to be a violation of paragraph F, there has to be, number one, a communication initiated, and number two, it has to be initiated using one of the methods that's listed in the regulation. Now, Mr. Lemberg made the same argument that persuaded the...
But could I just
Yes,
make
Your
your task just slightly more complicated? And back to Justice Cypher's point about that regulation. The AG has sort of put a gloss on this. And if it's ambiguous, as Justice Budd pointed out, or might be ambiguous, don't we have to take that gloss into account? And that gloss is, if you could have left a message, then aren't you getting into dicier territory?
Dicier, yes, Your Honor, but the statute says what it says, and the same AG regulations that are at issue here also say you can't communicate with a third person. And so while it's not physically impossible for Target to leave a message, we would be violating a different provision of the statute if somebody else heard that message. So we don't leave a message. And there is a fair amount of case law.
What does that provision say, the other provision? Says you can't leave a message that identifies them as a debtor, right?
You can't leave a message that conveys information about the debt. That's right. Something for which somebody could figure out that they owe you money.
So you could leave, as the chief asked earlier, you could leave a message that says Target calling, call back.
The case law goes both directions on that, Your Honor.
Okay, you can't.
Maybe, maybe not. I don't know whether we would be liable, but I think we'd probably get sued for that.
Well, you can summon devils from the deep, but that doesn't mean they're going to come. I mean, you can get sued, but you should win that case, right?
As I said, Your Honor, there are cases that go both ways. There are some cases where the creditor won. There are some cases where the creditor lost on that argument.
Meaning where you just leave a message saying, this is Target, please call me back, they've lost?
That's right.
Which cases are those?
Your Honor, there is, I believe this is the Rhodes case from the 11th Circuit. Right. So there are two cases that I'm pointing to, Your Honor. One, the most well-known one is the Foti case from the Southern District of New York, cited in our brief. It's 424 F Sup 2nd 463. There is, I believe, dictum in another case, Rhodes versus Olson Associates, 83 F Sup 3rd 1096. That's a federal court from the District of Colorado. Both cited in Target's brief.
So two district court decisions say that.
Right, Your Honor, and there's also an 11th Circuit case saying, well, there might be liability under that circumstance.
And that's liability under federal law.
Correct, Your Honor, under the parallel provisions of the Fair Debt Collection Practices Act. So, Your Honor, we've talked about whether there's a communication being initiated here. The Attorney General seemed to suggest that maybe there was. Cases applying this particular statute say the opposite. Judge Zobel's opinion in the Camacho case says no communication occurred, therefore no liability under the Massachusetts debt collection regulation. So, and of course, the Armata court, the Superior Court here said no liability because no communication. And being fully aware of the Attorney General's opinion because Mr. Lemberg brought it up. But that is one of the two elements that you need to get liability here. The other element.
So in Camacho, Judge Zobel rejected the interpretation of that gloss that the AG has put on it?
She didn't mention it specifically, but yes, she came to a different conclusion, and I believe.
Address it in her decision?
Kind of indirectly. Your Honor, what the.
I like that, kind of indirectly. Yeah.
I will tell you exactly what Judge Zobel says, Your Honor. It's 3 or 4 sentences.
Okay, go ahead.
What she says is, as for the volume of communications, unanswered phone calls with no message convey no information and so cannot be deemed communication under the plain meaning of the statutes. And she gives a citation, which I'll skip because it's a federal citation. Because the record therefore fails to reflect any 2 instances of communication within any 7-day period, the complaint fails to state a cause of action. This also eliminates plaintiff's count 2, Massachusetts General Law, Chapter 93A claim, based on defendant's alleged violation of 940 CMR, the regulation at issue here, for the same reason.
But she doesn't address the fact that the AG says that an unanswered, if you could leave a message, it's the same as leaving a message.
She does not specifically address that point, no, Your Honor. By the way, Ms. Camacho's lawyer was Mr. Lemberg. And this case came out two years after the AG opinion. So I don't know for a fact that she was aware of it, but it was out there, and the lawyer who is bringing it up here had the chance to bring it up there. Okay. And she certainly does address the point about whether an unanswered call is a communication.
Can I ask you the same question I asked your brother? Are you aware of the AG ever weighing in on one of these cases?
I'm not, Your Honor. Okay. So the second prong that could get to liability here, even if you disagree with Target on the communication issue, which I hope you don't, I hope that you follow Judge Zobel and the Superior Court in this case, but even if you don't, what the regulation prohibits is it prohibits a creditor from, quote, initiating a communication with any debtor via telephone, comma, either in person or via text messaging or recorded audio message, comma, in excess of 2 such communications in each 7-day period. Now, we've heard some language thrown around about subordinate clause, and I'm not going to spend a lot of time on this, but in our brief we point out why this is not a subordinate clause. But if you wanted these to be just illustrative examples, that's not how you would write this statute. You would say, initiating a communication with any debtor via telephone, for example, in person or by text messaging. Or you would say, such as in person or text messaging. But no, what this says is, comma, either in person or via text messaging or recorded audio message, close comma. That is a limiting construction. It limits the application of what precedes it. And Your Honor, even though we were calling using a predictive dialer, which is a kind of telephone, we were not calling in person. There was never any live human being at Target who was involved in these calls. There would have been if Ms. Armata had stayed on the line, but that never happened. We weren't text messaging. There's no dispute about that. And we were not initiating the calls via recorded audio message. Ms. Armata does say she heard a recorded audio message that played, and that might have happened. It would have said, please stay on the line for the next available representative. But there's no evidence that that happened more than twice in any 7-day period. And since we can't, and since the plaintiff can't hit any of those 3 kinds of communication that are covered under this regulation, there's no liability here.
Isn't the effect of getting one of these calls the same as getting the message? Meaning that, you know, when your phone buzzes and it says Target on it, and I understand also that if you're not home, obviously it's had no impact on you, but that's why I thought the AG's gloss kind of has a tipping to effect, meaning that if you could leave a message, we want you to be able to call twice, but we don't want you to be able to just keep calling. But I understand you don't believe in that, but my own logic says this is hard to follow. This is not the clearest thing the AG has ever written, and we're looking for some kind of interpretation of it. It would be nice if they showed up to interpret it, but they don't. So all I've got is what they've got there.
Well, Your Honor, we do have a little bit more than, so we've got the text of this paragraph, which we've talked about, and we've got the AG's, the gloss, the guidance, which of course can't create a liability where the regulation itself created none. But we all...
Well, if we owe some deference to the expert agency, to the agency entitled to interpret this, they've seemed to have contemplated this kind of clever distinction that you two are fighting over. So don't we default to that?
If what they are saying does not fall within the language of the regulation, then no. You only default to their interpretation if there is an ambiguity here. And we say that if you look at the regulation itself, there's not room for an ambiguity. But there is one other place from
You say
which...
this thing is unambiguous. Okay.
Well, because it gives you these specific 3 ways that you can violate this paragraph, and it lists only the 3, and it does it in a limiting way. So we don't think that they can create new ways of liability without actually amending the regulation. They can't just say, oh, and we also meant to say, it does say A, B, and C, but we also meant D, E, and F, and we're adding this now, but even though it's not in the regulation. They can't do that. But, Your Honor, there is one other place from which we can take interpretive guidance, and that is the rest of the regulation itself, which was written by the same hand and adopted at the same time in the same process. Paragraph F, which we're talking about now, the violation is initiating a communication in one of these 3 ways. But if you look at paragraph G, it says placing telephone calls. H, placing any telephone call. We know that placing a telephone call, in other words, an attempted communication, must be something different than initiating a communication via telephone, because they use different words. If you look at paragraph D, 2 paragraphs earlier, communicating by telephone with no limitation, we are able to read from the rest of this regulation that paragraph F, initiating a communication, means something different than just placing a telephone call, which is all Target was doing here, and means something different than just communicating by telephone with no qualifier, because they said that in paragraph D, and they could have said it the same way in paragraph F, but they didn't.
Now, the definition of communications, I gather, also excludes non-identifying communications.
That's right, Your Honor.
And a non-identifying communication is defined as a call to someone other than the debtor?
Well, it's a call to the debtor where somebody else picks up. So it could be, for example, a non-identified communication would be Target calls Ms. Armata's number, somebody else answers the phone, and Target says, is Ms. Armata there? And the person says no. And the caller at Target says, well, do you know where, is there a different number I should reach her at, or do you know when she'll be home? That's a non-identifying communication.
Okay, can you say, this is Target? Can you ask her to call her back?
I think we can, Your Honor.
But does that make it an identifying communication? I'm trying to figure out that, those I gather are unlimited.
So the definition of non-identifying communication says any communication with any person other than the debtor in which the creditor does not convey any information except the name of the creditor, and in which the creditor makes no inquiry other than determine a convenient time and place to contact the debtor. So I think we can say, this is Target, do you know when she'll be home?
And there's no limit on those, I gather.
Correct. They don't fall under the regulation, just as the kind of calls we were making don't fall under the regulation.
All right, and one last question, maybe perhaps the last question. If we were to decide, I don't know whether we will, that the AG's guidance is to be applied, is it your view that you are, quote, not able, or that you are truly unable to leave a message for the debtor?
We are, correct, Your Honor. We are unable to leave a message for the debtor because it runs the risk of violating the other provisions of the same statute.
Of the statute or of the federal statute?
No, I'm sorry, Your Honor. There are similar provisions in the Massachusetts regulation.
Oh, I see. So you're saying there are also regulations which say you can't tell my daughter that her dad owes money.
That's correct, Your Honor. And those provisions are both in the federal statute and in the Massachusetts regulation. So it's not that we would run afoul of the federal statute. We would run afoul of the very same regulation that the Attorney General was interpreting.
What provision in that would you run afoul of?
Give me just a moment. Your Honor, so we're looking at 940 Mass Code of Regulations, Section 7.04F. That's what we're looking at. That's the one at issue here.
Right.
Section 7.061A.
7.06A?
7.061A prohibits implying the fact of the debt to any such person, that is a person not covered under the definition. They also prohibit, and Your Honor, this is Section 7.04D, so 2 paragraphs before the paragraph that we're looking at, prohibits communicating by telephone without disclosure of the name of the business or company of the creditor.
But you could, again, with the chief's point, this is Target, call me back. Why does that run afoul of the 2 provisions you've just cited? Because if you're calling the debtor, you can say this is Target, right?
We can say this is, well, that's right. We can, if we're calling the debtor, we can have a normal communication.
Well, but again, so why are you unable to leave? I want to know why. I understand your thing turns off because there's no one there. But
right.
Why couldn't it leave the message? This is Target. Please call us at your convenience. And that violates 70.061A. Why?
Because it's implying the fact of a debt to a third party who is not the debtor.
No,
So
but
if somebody hears that
I'm saying you're calling the debtor. You're leaving a message to the debtor's house.
Because we don't know who's going to listen to that message, Your Honor. If somebody else hears it, we will have violated that provision.
And is there a case interpreting that as an implication of debt?
There are a number of such cases, none of them under the Massachusetts statute, but under the federal statute, there are, Your Honor.
And do you know whether you're calling a cell phone or a landline?
We do know, Your Honor. We have known since 1915, simply because
Since 1915?
Excuse me, since 2015. We're good, but we're not that good. Your Honor, the federal statute, the Telephone Consumer Protection Act, liability under that depends on whether the call is being made to a landline or a cell phone. So since 2015, we've established whether we're calling one or the other.
Okay, thank you.
Thank you, Your Honor.